So good morning, everyone, and thanks for joining us today for our final presentation in the Employment Law in Financial Services webinar series. As you'll know by now, these are bite-sized introductions to employment law considerations specific to regulated financial services businesses. And we've been looking at those considerations throughout the life cycle of an employee. My name is Jamie Meehan, and I'm a Senior Associate in the Employment Law team here at Burness Paul, and I'm joined today by Lorna Stephen, an Associate in the Financial Services Regulatory team. Today, we'll focus on what happens on termination of employment, including the use of settlement agreements on exit and the requirements around regulatory references. As always, a little bit of housekeeping before we get into the swing of things. So just a reminder to keep your cameras and microphones off during the presentation. We will be recording today's session, and the recording will be distributed afterwards. And just in terms of questions, we may not have time for questions today, but our contact details are on the final slide, so please do get in touch with us if there's anything you would like to discuss, or feel free to pop any questions in the chat as we go along, and we will come back to you after the webinar on those. In terms of the agenda on the slide there, so today we will look at some general employment law considerations when dismissing an employee, the use of settlement agreements in a termination scenario. We'll then go on to look at regulatory notifications and references, and then finish off by looking at the requirements around employee handover on termination. So moving on then to think firstly about the general employment considerations when dismissing. As always, I think it's useful to start by and just remember that general employment law considerations will apply in the financial sector just as in any other sector. In a general sense, that means you should identify a potentially fair reason for dismissal, of which there are 5. So that's conduct, capability, redundancy, illegality, or some other substantial reason, and then follow a fair process, particularly for employees who have sufficient service to bring an unfair dismissal claim, which is currently 2 years. We discussed what a fair disciplinary procedure would look like in the last webinar, which is the procedure you would follow in a misconduct case, and some of the principles from that will apply equally to other types of dismissal process as well. And it's also worth just checking and just kind of sense checking that there's no discrimination or automatically unfair reason at play, such as whistleblowing. I think particularly if you're in HR or legal, and you have a manager looking to dismiss someone, it can be helpful just to test their reasoning to ensure that there is a potentially fair reason there before you get started with the process. Not only will the reason for termination have a bearing on what claims the employee might be able to bring, but it will also affect whether there is an entitlement to notice or not, and may also be relevant in relation to the triggering of good leaver, bad leaver provisions in a share plan or in the company's articles of association if the employee holds any shares or share options, which is fairly common in this sector, particularly at the more senior level. Once the decision to dismiss has been made, consider what the notice requirements are. So have a look at the contract to see what that says about notice. Think about whether you can and or will have a garden leave period, whether there are any post-termination obligations at play, such as restrictive covenants, and always good practice to have a well-drafted dismissal or termination letter, which sets all of this out. Employees with 2-year service have the right to written reasons for the termination, and it's also good practice for employees with less than 2-year service, as it can be helpful to show the reason was a potentially fair reason and not an automatically unfair reason or a discriminatory reason. And then usually you should be allowing the right to appeal against the dismissal decision as well. In particular, you should check whether there's a pile-on clause in the contract, so that's a payment in lieu of notice clause. And if so, that will usually specify exactly how notice will be calculated, such as whether it's basic pay only, or whether it includes other payments like bonus, holidays, commission, and so on. When considering the ways in which contracts of employment can be terminated, it's important to remember that a fundamental breach of contract by one party will release the other from any obligations under the agreement. So that means that if an employer wrongfully dismisses the employee, such as by paying in lieu of notice without a pile-on clause, it will not then be able to rely on restrictive covenants in the employee's contract. So it can have quite significant consequences if you don't dismiss in accordance with the employment contract. So always best to check the contract first, potentially take advice, and then also consider whether a settlement agreement might be a useful way to be clear on all of this. So, for example, you could reimpose restrictive covenants in the settlement agreement just to be really clear on that. If the employee is also a director, then there can be some, or there will be some additional considerations there. So, and that will be particularly so for listed companies. So that might include things like whether shareholder approval is required, and if so, what that looks like, whether the termination itself or the payments need to be disclosed or reported, and you'll also want to think about any steps needed to be taken to remove the director from office, which is obviously separate to their employment. So moving on now to consider settlement agreements, which can be used on termination of employment and which we see fairly commonly in this sector. Settlement agreements have always been an effective tool in an employer's armoury and can guard against employment tribunal claims, if of course done correctly. There are other benefits too, such as agreeing an exit on amicable terms and or agreeing announcements with both the employer and employee's reputation in mind. There are certain requirements for a settlement agreement to be valid in the UK, and so for it to properly waive employment claims, we need to make sure that those requirements are met, and the employee needs to take their own independent advice from a relevant advisor, and in practice that's typically a lawyer. In terms of the requirements I touched on, so the agreement needs to be in writing and it must identify the advisor. It must specify the particular complaints or proceedings it is in settlement of, and it must specifically state that the conditions relating to settlement agreements under the relevant statutory provisions have been satisfied. Just in terms of what you tend to see in agreements, so the settlement agreement will set out when employment will end and on what terms, including what the employee will be paid, on what basis and when. Just a quick note on tax here as well, because I think getting the tax treatment of those payments is really important, particularly with respect to the post-employment notice pay rules. Taxation can sometimes be a bit of an afterthought once the payment has been agreed in principle at least, but if an employer fails to deduct tax or national insurance contributions from a termination payment, it is the employer who's generally liable for that. And in addition to any unpaid tax and national insurance contributions, HMRC can also recover interest and penalties from the employer as well, albeit settlement agreements do typically include provision for recovery of at least some of those liabilities from the employee. And just to flag as well that there are some differences between Scotland and England and Wales when it comes to settlement agreements, particularly in relation to execution. So always worth making sure you bear that in mind too. At Burness Paul, we can advise on both, so very happy to help whether the agreement is governed by or in relation to a Scottish-based employee or in England and Wales. Just thinking about some particular financial services considerations then when we are drafting and negotiating settlement agreements in this sector. One thing to bear in mind, obviously, as has been a bit of a theme in the webinars, is the reason for termination, including because it can have reporting and other regulatory implications. And so sometimes what we see is employees asking as part of the negotiations to see a copy of the draft report to the regulator, and or the draft regulatory reference so that they can provide comments before it's finalised. So sometimes that forms part of the settlement agreement negotiation. It linked to this is that consideration should be given to any particular shareholdings, share options, and other bonus and incentive schemes. Think about any malus and clawback arrangements, and the settlement agreement should not restrict the ability to operate malus and clawback in line with the firm's remuneration policies or similar. The settlement agreement terms should also ensure that the exiting employee will cooperate with future regulatory investigations, legal proceedings, and or other internal proceedings such as disciplinary investigations. So you'll want clear provisions to that effect. The confidentiality and non-disparagement provisions are also particularly important in this sector, including to ensure that it's clear that nothing in the agreement prevents the employee from making a protected disclosure. In other words, blowing the whistle. And again, we touched on that in a previous webinar too. It's also good practice to explicitly carve out any other exceptions or restrictions to the general confidentiality provisions, including to allow reporting of misconduct or breaches of regulatory requirements to appropriate regulators, reporting offences to the police or other authorities, being permitted to disclose in the context of seeking tax, medical, or other professional advice, and so on. The warranties clause will also be worth looking at through a regulatory lens. You might, for example, want to include a warranty that the employee is not aware of any facts or circumstances that amount to a breach of the regulator's conduct rules. And I suppose something that we see coming up quite often and which you want to think about is, what if you enter into a mutual settlement agreement before any findings are made or sanctions issued in respect of certain allegations against the individual, against the employee? And should those be disclosed to the regulator or in regulatory references? There is some guidance out there about this to suggest that a firm won't need to disclose information that has not been properly verified, but that it may choose to do so. And this effectively means the judgment is left up to the individual firm. And so in practice, you find some firms will err on the side of caution and will be liberal with their disclosures. But of course, employees will typically take the view it's unfair to disclose allegations which have not been verified, particularly at the more serious end, because those allegations could be career-ending for them. And so this often becomes an issue of contention in exit scenarios and comes up when negotiating settlement agreements in those scenarios. It can be very difficult in practice and always good to take advice. In our experience, it's about weighing everything up in the particular case. So in other words, it's a bit of a case-by-case call based on the particular facts. So for example, what has actually been disclosed, what evidence, if anything, has been uncovered so far, what is the nature of that evidence, what is the nature of the allegation, and so on. So it's about weighing up all of those factors before making a call on whether you need to disclose or not, and then how that informs your settlement agreement discussions and negotiations with the other side. And just a word on regulatory references more generally, before Lorna comes on to discuss this in more detail. It's obviously important to remember that settlement agreements must not contradict the regulatory reference rules. Typically, what you'll see is that the agreement will provide for a basic factual reference, which is common practice these days, whereby the reference confirms dates of employment and job title only, but that there will also then be a separate clause which says nothing in the agreement, including the provision of the agreed short form reference, nothing in the agreement will prevent the employer from complying with its obligation to provide regulatory references. And so with that, I will now pass you over to Lorna to discuss regulatory references and some other regulatory aspects when terminating employment in this sector. Thanks, Lorna.
Thanks, Jamie. I'll now go on to discuss some of the specific points to be aware of when an SM&CR employee is terminated or otherwise ceases their employment with the firm. Hopefully, some of these points will already be familiar to you, as these echo points raised in the early sessions of the series when we were looking at hiring employees. So moving on to the next slide, as I mentioned in the very first webinar in this series, hiring firms must obtain regulatory references for the past 6 years' employment for SMF and certified hires. The converse of this is that any firm terminating or otherwise ending the employment of an SMF individual must also provide a reference for former employees covering the past 6 years upon request. That request must be responded to within 6 weeks and cover all information relevant to a hiring firm's assessment of fitness and propriety. So as a reminder, the key questions which could arise in the context of an employee being terminated are: have you concluded that the individual was not fit and proper to perform a function? A question regarding disciplinary action that is relevant to breach of the conduct rules, or to whether that individual is fit and proper. And then the broad question G, are you aware of any other information you reasonably consider to be relevant to your assessment of whether the individual is fit and proper? So the information given in response to these questions must be fair, accurate, and based on documented fact. But as we mentioned, the any other relevant information point at question G is very broad, and can be a challenging one to answer depending on the reason for the employee's departure. However, this must be balanced against the firm's obligation to deal with the regulator in a fair and open manner. So it can be quite a difficult one to establish what should be disclosed at that point, and certainly goes beyond the factual reference that Jamie mentioned before. Firms must also retain records of former employees' conduct and fitness and propriety information for 6 years following termination in order to be able to meet this obligation to provide the references. Firms will also need to ensure that any documents referring to the senior manager who has left are updated, such as statements of responsibility. So it's worth making sure there is a process in place to capture those updates following any termination or cessation of employment. So the firm is also under a duty to notify the FCA no later than 10 business days after an approved SMF manager permanently ceases to perform an SMF function under the provisions of the supervision manual. If the senior manager is leaving the business entirely, the notification would be made through a Form C, which provides details of the senior manager function ceasing to be carried out and the reasons for this. And that can include things like resignation, internal staff moves. So, your general just day-to-day turnover, as well as more serious ones like dismissal or suspension. And these require a full explanation to be given on the form. And you would also need to specify if any conduct rules have been breached as a result. If the senior manager is just moving on to another role, another senior management function within the same firm or group, then use a slightly different form, and that's a Form E. So firms should also note that they have an obligation to supply the FCA with complete and accurate information required by Form C, irrespective of any settlement agreements entered into between the firm and the employee, as Jamie's already mentioned. And a regulated firm should not enter into any such arrangements that could conflict with its obligations under SM&CR or the regulations more generally, and that includes this requirement to provide a regulatory reference. However, it's not only these external duties, like notifying the regulator and providing references, that firms need to take account of. Ultimately, when a senior manager ceases employment, their work will need to be taken over, and the person taking on that work will need to know what the current state of play is. The overall regime takes account of this, and where a firm is subject to SM&CR, it's required to ensure that all senior managers taking on a new job have all the information and material that a person could reasonably expect to have to perform the job effectively in accordance with the requirements of the regulatory system. the obligation with regards to specific handovers applies to enhanced firms only. So not all solo FCA regulated firms are going to be subject to this requirement. The firm is also under an obligation to have arrangements for an orderly transition between senior managers, including taking reasonable steps to ensure that any predecessor contributes the information and material required, which could be implemented through a handover certificate. And it would be wise for firms to specify what they expect to be covered in any handover to ensure consistency in the work. And some things that you may want to include as topics for the handover policy to be included in any handover that the senior manager is required to provide would be a judgment of the risks and any concerns a senior manager has. So that might be kind of new risks emerging in the last 6 months, or there might be kind of wider issues that they feel are relevant to their responsibility as a senior manager. How the senior manager discharges their duties and the reporting lines within their area that they're responsible for. And it's very important to keep this up to date throughout the senior manager's appointment in the role, as we mentioned in session 2. The level of resourcing and capabilities within that senior manager's team. So that is how well resourced the team is to carry out the functions which are the responsibility of that senior manager. And any regular interaction or scrutiny that has occurred within the business area, which might need to be picked up by the next senior manager to hold that position. So with that in mind, it can be worth considering whether to include contractual provisions around the requirement to provide satisfactory handover notes and cooperate with the regulated firm in relation to investigations relating to the individual's fitness and propriety following termination, as Jamie mentioned in the first half of this webinar. And on a more practical point, the senior manager would also be expected to hand back any company property and or records that they hold from their time as a senior manager. And so moving on to the next slide, whilst it's not strictly on the topic of termination, so forgive me the slight deviation here, there are also obligations to the regulators for temporary long-term absences. So where the employee is not leaving the firm, but will nonetheless not be performing their senior manager responsibilities for a given period. Firms are expected to notify the FCA when a senior manager takes temporary leave for longer than 12 weeks. For example, this could be in the case of parental leave or where the length of absence is not known. In cases where an individual who performs an SMF function is temporarily absent from their role and the firm intends to keep the role open for that individual to return to in the future, the firm doesn't need to notify the regulators that the individual's approval should be removed. So this means that the senior manager returning to that function following a leave of absence wouldn't require fresh approval from the regulator to perform that role, assuming that nothing material has changed in the meantime. So firms should still ensure that where the individual taking long-term leave is carrying out an SMF role, another individual is appointed to perform those responsibilities during the interim period. And again, where it's likely that it will be an extended leave of absence, any document setting out responsibilities should be updated to reflect the current position, even where this might be on an interim basis. And finally, if the senior manager has been absent for more than 12 weeks, the firm must notify regulators within 7 business days of the end of the 12-week period. And firms will also be asked to provide the effective date for the change, so the point at which the person is beyond the 12 weeks there. And then firms are also required to notify the regulators within 7 business days of that employee's return to their role. So that brings us to the end of today's presentation. Jamie has given us some great background to some of the general employment law considerations when dismissing an employee, including procedural fairness and some upfront considerations to keep in mind, as well as the use of settlement agreements in a termination scenario and the financial services specific considerations around settlement agreements. I've discussed the need to notify the regulators on termination of an SM&CR employee and the requirement to provide regulatory references, as well as more practical requirements around handovers between senior managers. So not only does this bring us to the end of this webinar, but it brings us to the end of our series. We hope you found these webinars useful. We'd love to hear your feedback on the sessions, including whether there is anything you'd like us to cover in future webinars. And if we can assist with anything we've discussed during the course of this series, please do get in touch with us, and our contact details are on the slide there. So thank you so much again for dialing into these. We really appreciate you coming along, and I hope you enjoy the rest of your day. Thanks very much.